Texas is an open carry state. So why do people keep getting arrested for having a gun? Let me paint you a real scenario. A man walks into a grocery store in Houston, gun in his hip. He's calm. He's legal. He thinks he's doing everything right. 10 minutes later, police lights, handcuffs, a criminal charge that could follow him for the rest of his life. If you own a firearm in Texas, what you don't know can absolutely ruin you. And today, I'm going to explain exactly how that happens. My name is Ruben Restrepo. I'm a criminal defense attorney. I do a lot of DWIs. I also do immigration attorney. I help people with gun-related charges all the time. In the next 8 to 10 minutes, I'm going to break down when open carry is legal and when it's not, and 3 situations that otherwise law-abiding Texans get arrested, even though they thought they were protected by the law. And I want you to stay with me until the end because the most dangerous mistake people make with open carry isn't the obvious one. Also, read some real unlawful carry charges. Okay, before we go any further, if you care about protecting your freedom, your rights, your record, subscribe to this channel. I'll break down Texas criminal law in plain English so you don't learn the hard way. All right? Okay, let's start with the truth. Yes, Texas is an open carry state, but that doesn't mean that you can carry anywhere, you can carry however you want, or that police can't stop you. And this is where people get into a lot of trouble because they have a lot of beliefs. And here's what most people don't realize. Open carry in Texas is permission based. It's not freedom based. You are allowed to openly carry a handgun only if you're legally eligible to possess a firearm. That usually means it's age based. The gun is carried in a holster. You are not in a prohibited location. Miss one of those and you're facing charges. And I know that can be super frustrating. Let's talk about mistake 1, prohibited locations. This next part is where people get arrested really fast. Even with open carry, you cannot carry in places like a school or school grounds, government buildings, courthouses, bars that make most of their money from alcohol, private businesses that post proper gun restriction signs. I had a client, no criminal history, who didn't have his gun in a holster when he was pulled over for a traffic stop. The gun was considered in plain view. That mistake cost him an arrest, thousands of fees, and months of anxiety over his permanent record. So let's talk about mistake number 2, disorderly conduct. Most lawyers won't tell you this, but this is where police get creative. Texas law allows officers to arrest somebody for disorderly conduct. If a firearm is displayed in a way that causes alarm, someone calls 911 claiming they feel threatened, even if your gun is legal, even if you never touched it, even if you never said a word, right? Perception matters, right? And perception gets people arrested. So it's important to know the law. Now let's talk about mistake number 3. Prior issues you think don't matter, right? Now stay with me. This next part is the one that saves people years of trouble. All right. Old cases matter. Protective orders matter. Pending charges, they matter. Certain mental health commitments, they matter. I've seen people get arrested because they didn't realize a past issue still legally disqualified them from carrying. And once that arrest happens, ignorance is not a defense. Open carry is not about what you can do, it's about what you must avoid doing. The law is technical, police discretion is real, and the consequences are serious. All right, now I want to start talking about. I want to see what some of you guys say. So here's the bottom line: Texas allows open carry, but only inside very specific legal guardrails. This is where it gets powerful. Drop your questions in the chat because some of the most important insights always come from real life scenarios, not hypothetical ones. I can give you some hypotheticals, but if you got some real life questions, I might be able to answer those. Okay, so if you've been arrested, question, or you're unsure whether you're legally allowed to carry, don't guess, right? There's going to be a link in the description above, below, depending on where you're looking at. Use it. Call my office. Let's get a consultation. Let's see if I can help you save your freedom, your record, and your future. All right, I promise you some real charges. I'm going to read the relevant part. Okay, so let's start. If you basically, it's going to go with if there was that person, they're going to name that person, and they're going to say they was in Harris County, Brazoria County, Montgomery County. They're going to say all of that stuff, right? And then they're going to accuse that person or you, right? Did then and there, and here's the part: unlawfully carry a handgun and intentionally display the handgun in plain view of an accuser, right? This is generic, but it would have a person's name in a public place, namely the address in, like, let's say Houston, Texas, and the handgun was not carried in a holster. So this is one where, like, it's almost like that disorderly one, right? But maybe nobody was scared. But the point is that somebody on viewed you in a place that's not your own, right? Basically, I don't want to say waving the gun around, but having the gun out of the holster. It's maybe not even in the holster. And yes, you definitely can get arrested. I have seen this scenario a lot with, like, exes, people that have been divorced and somebody's coming over. People try to say, oh, well, he was drinking, so I didn't know what was going on, but they can't really show that the person is intoxicated. Guess what? There was nothing in there about intoxication. Let's talk about another one. Okay. Unlawfully, intentionally, and knowingly carry on and about the defendant's person a handgun while not on the defendant's premises or premises under the defendant's control, and while not inside of or directly en route to a motor vehicle or watercraft owned by or under the control of the defendant, and the defendant was younger than 21 years of age at the time of the offense. So I'm sure you already guessed now that the biggest problem here is the fact that under 21, right? So somebody under 21, can they have a gun? There's a lot of law, especially recent law, that I actually use myself whenever somebody gets discharged. However, people get discharged all the time. And the biggest problem is that you still have to challenge this. You still get arrested. They still can find PC, and you still need a lawyer to challenge it based um, on the Fifth Circuit decision, right? So there are some decisions out there that says maybe somebody that's younger than 21 years of age can carry, but mostly those people are ones with CHL, right? Concealed handgun license. But everybody else, they're definitely subject to this. That's the law that's in the books. It hasn't been redacted, and it definitely gets used against you. So if you're arrested for it, you can't just be like surprised. You can't just say, "Oh, officer, what about this particular case law?" They're gonna be like, "Let your lawyer handle that," and your lawyer will handle it and point that out. And a lot of times the judge will agree, and it can go away. The biggest problem is, though, you've already been arrested. Maybe you had to put bail, especially like a smaller county. You already had to put bail. Like, oh my God. So let's continue on. What's another one? Unlawfully, intentionally, and knowingly. Okay, so let me mention that part. It's always going to say, a lot of times it's going to say unlawfully, right? It's like, well, that doesn't really mean anything. It just means that, it's illegal. Okay. But the bigger part is actually intentionally and knowingly. So that means that they knew about the gun. Whoever got arrested knew about the gun and they were doing it on purpose. Now, this is a big deal. You keep hearing this. So this is an intentional crime, right? So there's a little bit something more I'm going to talk about a little bit after I finish reading this, but that's one thing I just wanted to point that out because you're going to keep hearing that. Okay. So unlawfully, intentionally, and knowingly carry on and about the defendant's person a handgun in a motor vehicle under the control of the defendant, and the handgun was in plain view, and the gun was not in a holster. So, as you can see, that one was pretty big. It was a lot of ands. Now, what does that mean? That means there are a lot of elements to this, and the elements connect. You can't separate the two. So the gun was not in a holster. If the gun ended up being a holster, everything ends up falling apart, right? If the gun was not in plain view, the whole charge ends up falling apart. So these are points in where a defense attorney like me will try to look for it and try to, you know, just take out these little Jenga parts so that the whole thing just collapses and then we can go for our dismissal. But that's where you can be like, well, hey, I'm going to go ahead and make sure that my gun is already in a holster. So it's just not an issue, right? It's just in a motor vehicle. A lot of times, a person, cop's not going to mess with you, right? At that point. But usually something like this is actually connected to something else. Like, why is a cop interacting with you in the first place? That might be one of the questions that you have to ask. Not what is legal and what is not legal, but why is there any kind of interaction in the first place? Because usually, especially Texas, people love to have guns. So why is there any issue in the first place? It's gonna be because the police had to interact with you, usually for something else, not because they're so fixated on a gun. So when they see that gun, they're like, okay, maybe a lot of times they had nothing else to arrest you on. They wanted to arrest you for marijuana possession, but then there wasn't really anything there. And so then they go, okay, well, we're just going to add something else to this. Oh, I know. We found this gun. He's in possession of the gun. Bam. It's his gun. So he has it right here. Here's the charge. All right. Okay, let's move on. Here's a similar one, but that this one attaches a crime. Unlawfully, intentionally, and knowingly carry on and about the defendant's person a handgun in a motor vehicle under the control of the defendant, and the defendant was engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic, namely reckless driving. So, whoa, how about that one, right? This one is attaching reckless driving. Now, some of you actually might be very perceptive. You might be like, wait a minute. I was in traffic court and I had a reckless driving, and all I had to do was pay a fine. I could seriously get a handgun charge just because of that? The answer is yes and no. A lot of times, reckless driving, when you get a ticket, will only be something like you're traveling at 26 miles per hour. You see, you kind of have to be worried a little bit more. You have to be a lot more reckless in order to be arrested for reckless driving. And reckless driving, when you're arrested, can land you in jail. But here's the crazy part: the maximum is 30 days. So once they keep you 30 days, they gotta let you go. And if it's one of those places like Harris County where you have like the 1 for 3, I mean, we're talking like 10 days. So the conviction usually doesn't happen. But the main point is that, like, let's say you got into an accident or you almost got into an accident and people had to avoid you. You see, a lot of times when you see those videos about a drunk driver weaving through all of the lanes, right? They just can't stay in there. What they are not getting pulled over for a DWI. They're not getting pulled over for drunk driving because you can't know if they're drunk driving unless they had alcohol or um, a drug or something like that. I mean, think about that. You would never know that. What's really going on is that when people say, "Oh, we pulled them over for a possible DWI or possible intoxication," what they're actually saying or should be saying is that they pulled them over for driving reckless, for reckless driving, right? Because they don't know if the person had alcohol. What if the person had a stroke and that's why they were driving that way? Well, then they're going to take care of them, but they're not going to be able to give them reckless driving. Or what if they were messing around with their phone? Oh no, yeah, they're going to be able to give you the reckless driving. So that's where this is just a one way to connect a crime. So essentially, you had this, and it's not really, if you notice, it wasn't really talking about, oh, it wasn't in a holster, right? It was about there was a crime going on. It was something that you can be arrested for, at least a misdemeanor B. So DWIs are often connected to this stuff. You were doing something along the lines of DWI, and you had a gun in the car. I know it sounds ridiculous. The gun had nothing to do with this supposed crime you were connected to, but the gun should not be in the car. I mean, but oh, if you get in an accident, so what? If the gun's in a holster or the gun's in a glove box locked away or nobody could see it, what's the issue? There is no issue. However, they can arrest you. That's our issue. That's your issue. They can arrest you and give you this. So now you have an extra charge. You don't just have one, you have two that you have to deal with. Okay. So Texas gives you rights, but it also enforces consequences. Make sure that you understand both. Okay. So let's look for the comments. Okay. So let's talk about something that people often are asking me, having a gun. So you have a gun and then you end up somewhere and you end up getting arrested, or can you have the gun pretty much anywhere? So let's say Starbucks. The answer is kind of yes. I mean, that's kind of the point of a open carry is that, yeah, you can go to some place like Starbucks and have the gun out. Um, most of sometimes people they don't like that and it seems very scary. However, that doesn't necessarily mean that that's just going to be something that you can get arrested for, because I mean police officers go to Starbucks too and they have guns and they're in holsters. So that obviously some people can be squeamish, but I feel like most people, if the gun is in a holster, they're probably going to think you're like a cop or something, and they're just not going to bother you. Now if that gun is just in the back, right? And it's visible, oh yeah, somebody's probably gonna call the police. So you gotta be careful about that type of stuff. And then if the police end up interacting with you, then they're gonna start going through all the stuff. Well, did you touch the gun? Well, the gun is visible. As long as a lot of times, as long as that gun is visible and it's touching you, it's on your person, right? Now, I also told you that I was going to talk about something else, which was how do we link a gun to you? Remember, I said you actually can be driving. You're driving. There's a gun in the car. Well, guess what? I don't have guns. Right? No, I'm not trying to do anything. And I live in a pretty safe neighborhood, guys. I'm sorry that I do, but it's not really much of an issue. But how can this affect you? Where maybe you do need to have a gun, or someone who uses your car has to have a gun, right? You're going to use a car, somebody else's gun, they don't have it in a holster. and the gun, maybe the gun is in the little cubby right here. Now, guess what? That gun is not in plain view. However, if you got pulled over for a traffic stop and the officer asks you to get out, the moment that door opens, I can see it. It's right there. So guess what? Now it is in plain view. And they're going to say that. Well, I was able to see it in the cubbyhole, right? And that doesn't mean that it'll hold up all the way through a trial, but it does mean you're going to get arrested and have an extra charge. And if they really feel like they couldn't get another charge on you, bam. But wait, Ruben, you said it wasn't my gun. The premise is it's not my gun. That's correct. And so what are we looking at? What we're looking at is they have to put a link. So you're driving the car, right? Is the gun yours? Now, what I've done before is I got the owner of the gun to make an affidavit and basically accept that that was their gun. Now, that doesn't mean they're going to get their gun back, right? Because usually, in order to get rid of the case, they say forfeit the weapon. Then you always want to forfeit the weapon, right? So, well, we do a lot of different things. We make the owner get a holster or something along those lines, right? And then now they're going to feel better. And now they're going to release the gun after the dismissal through the reclamation process to the original owner, right? So, but what do I care? My client cares. They don't have a charge anymore. That charge is gone. And that's what's important. How about you're driving somebody else's car? Well, now we want to show that it's somebody else's car. However, the car was under your possession. And the cop's not really going to believe that some gun underneath the driver's seat that you didn't really know about it, right? So we got to do the same thing. We're going to say, oh, it belonged to the other person. But sometimes we're not able to do that, right? Sometimes the person doesn't want to admit it because they weren't supposed to have a gun, right? And you're just a passenger, and what do you mean there's a gun underneath my seat? And you're outside, you got handcuffs on. I don't know anything about the gun. It doesn't matter that you say you don't know anything about it. You're still going to get arrested, and they're going to be able to say that it was for you. However, an attorney is going to do something a little bit different. An attorney is going to say, hey, you got to put an affirmative link, right? Link the two so that it becomes one. And it's like, there's one way to link somebody is actual possession, right? So we have different types of possession. We have constructive possession and then actual possession. So what is a constructive possession? A constructive possession is a gun in a car underneath your seat and you are the passenger, right? And so a lot of times officers pull somebody over and they're walking and then they see that somebody's going like this. Hey, what happened to the guy? He disappeared, right? And of course, they're seeing the back of the person as they're walking up. That's going to put them on alert. Oh, what are they doing? Now, it might have been you just drop your phone. Could be that you're just trying to pick something up. Multitude of reasons. But when they see that, they think it, right? Even if you just sneeze, at you, right? Now it looks like you went and did something. Now they're thinking that. And there happens to be a gun that's got no connection to you, but that's how it's connected. You're in that car. So they search, they find, now you're arrested. But it's not your gun. However, there was a call. There was a I forgot what I was saying. It was like so there's actual possession, and then there was a constructive possession because you were around it. You're around the gun. It was within your vicinity. I mean, I don't know. Think of like Dungeons and Dragons, right? And just within your vicinity, there can be an attack point. And guess what? There you go. That gun was within you, and you could have grabbed it and you could have used it. And so they're gonna say that, but it has to be an affirmative link between the constructive possession and then assuming that it's actual possession, because otherwise it's like a magnet, up same sided magnet. No matter how much you try to push it, it's not going to get together. So that's a lot of times how we fight it. and it's the law, right? I'm sure you can understand. Case law basically says, hey, look, sometimes kids are using drugs and the parents don't know about it, and then parents get pulled over, and it sure smells like some weed. Well, I don't smoke weed. I don't know what you're talking about. I know it stinks, but I thought it was a skunk. No, it was some weed in your car that your son had left behind. Ooh. But does that make you guilty? What if he left coke behind or Xanax or something? All that stuff is just straight felonies. So, but they got to be able to show the affirmative link other than it just was in your possession, because that's where their weaknesses come. A lot of times, that's why you see either the case gets dismissed or you have something favorable, like a reduction to a misdemeanor C with drug paraphernalia or something along those lines. Okay, so make sure that you follow, put questions so I can go in the future and answer them. I'm going to end the stream.